Welcome back. Now next on stage is Felix, the only lawyer I know that is able to code, and that's really cool also to interact with him on the legal topics we have and the challenges in open source usage. So Felix, thank you for joining us. Stage is yours.
Thank you, Roger. Thanks for having me. And now for something completely different. Yeah, I think it's a good sign that most of you came back, so I take it as a good omen here.
We all fear the legal team.
Oh, okay, good. So, who am I? Felix Mannewitz. My team and I, we advised the Siemens CIO and her organization, and we also take care of open source legal topics since about forever, I would say. So whenever we have a legal topic around open source, the probability is high that it will land on my desk at some point in time. I know the output is not really standard conformant. That's up to my creativity here. Sorry for that. And enough with the background. I have to show you this little slide here. So here's a disclaimer. So this is not legal advice, okay? If you need legal advice, you have to get your own legal advice. Why do I say that? Because it's a public event. Yeah? So if this would be a Siemens event, it would be a little bit different. But yeah, I am a lawyer, but I'm not your lawyer, okay? It's also not the official Siemens position, but it might be. So, let's jump right in. I think I do not have to explain what GitHub Copilot is and does. And GitHub Copilot, by the way, it's just the headline. This can be applied to all similar technology, all the generative AI tools that are around, that are being developed. And I split this presentation in two larger chunks. One has a look at the input side. What is allowed? What can you do? What do you have to take care of? And what are the implications if you create AI models and use them in a product? And what impact does it have on open source? That's another aspect that I added to this presentation here, and I will perhaps spend more time than I would normally do. The other part takes care of the output side. So what can you do with the code that is being generated by a tool like GitHub Copilot? So Copilot is advertised as your pair programmer. So it's a helper tool that helps you to code more efficiently. That's the statement. Create code quicker than you would do manually. Boilerplate topics like that. And to make that work, an AI model is necessary. And for Copilot, that is called Codex. And to produce such a model, you need to analyze vast amounts of data. In the case of programming, vast amounts of source code repositories. So that's what's being done. GitHub, OpenAI, they harvest millions and millions and millions of open source code repositories to build this Codex AI model. And of course you can ask, is that okay? What's the basis for doing that? Because what does creating an AI model entail? Normally you have to build a so-called corpus. Yeah? So you need the data that you used to harvest, to dissect, to analyze. You need to get it from the original source to a point where you can do this analysis. So you need to copy. And for all of you who are experts in copyright law, know that the owners of a copyright, they can prevent you from copying. So they have an absolute right. They could exclude others from, for example, copying. And now the question is, why is someone able to create an AI model if you have to copy the code as a first step? And the first reaction is, that's possible because it's open source. And that in the end I have to say it's not the case, because you have to differentiate here between the US and the EU. That are the two jurisdictions that I took a closer look. The answer to the question why it's legal in the EU is that we have explicit rules there for some time now. So it's an EU regulation coming from 2019, which became law in Germany in 21, which allows for so-called text and data mining. Text and data mining is the process that you use to create such an AI model. Yeah? And this regulation allows you to do this kind of harvesting, analyzing, and also creating the copy that you need to have in the first place. Why? Because this was deemed as necessary for the advancement of R&D, of education, of science, and so on. And if you want to avoid that in the EU, you can. You have to opt out of that. So if you, as an open source contributor or owner of copyrighted code in open source repositories, do not want that, you have the possibility to opt out. But you have to do that in a machine-readable way. So you have to provide some kind of robots.txt with the content that you do not want to participate in this text and data mining. And here's the first thing where I talk about the impact on open source projects. This might clash with some basic principles in open source, because there is one of the principles: everyone should be able to learn from your code, to study the code. That's one of the basic principles. That's one of the cool things about open source. Of course, you can ask, is this the same like doing this kind of text and data mining on this huge scale and automatic analysis? So that's arguable, in my opinion, but that's the answer for the EU. From the open source perspective, you also have to think about, is it really still open source if you would opt out? Yeah, so that's difficult, I would say. There are also discussions in the open source space and the communities to say we need a new license. It's always a good idea to create new open source licenses, by the way. No, please don't. But here there are discussions ongoing to say we need some additional clause that prevents and opts out. And then again you have people who say then it's no longer open source. That's against the principles. Yeah? So we have to wait and see what the outcome there is. Interesting, in the US the situation is a little bit different. There is no such text and data mining provision. In the US, the basic argument that will deciding, in my opinion, is this so-called fair use argument. Fair use is a principle in the US copyright, which does not exist, for example, in German copyright law. And I don't want to bore you with that, and I'm not an US lawyer, but it's a 4-factor test that you need to apply. One of these factors is to see how transformative a use is. And I will cover that in one of the later slides. I think it's one of the key points in the lawsuits that already exist in that space in the US. Also, the GitHub T's and C's, I mentioned them on the slides. That's kind of a backup argument for me. They have provisions in there that they can analyze code, but it's really disputed, I would say, if that is clear enough for this kind of model creation, what they did. So that's also open, but they still also have that argument as a backup, I would say. So, what did I forget? I forgot one thing. Switzerland. So I'm a German lawyer, but I was interested, what's the text and data mining regulation in Switzerland? And I found out yesterday that Switzerland also has a text and data mining regulation, but with a little twist. So in Switzerland, text and data mining is allowed for educational and research purposes. And they did one more thing. They scoped out computer programs from it. So wouldn't be possible here in Switzerland. Interesting. And now let's go to the next slide. Oh, and one thing I forgot that also, even though you all are copyright law experts, what does copyright law protect? So copyright law protects the expression. What does that mean? It protects the code that you write. It does not protect your idea that you have to write that code and what's behind it. It just protects the output. So that's the basic principle. Will become important later on in this presentation. So let's go from the input side, model creation side, to the output side. There I have 3 little slides for you. The first one is a little background. And the first thing that you need to understand, and where I also needed to dig in a little deeper last year when this topic first came up, is tools like GitHub Copilot, they do not copy code, but they synthesize code from their model. That's an important distinction. Yeah? The thing is, GitHub themselves, they say that in about 1% of the cases, here I have to be careful what I say, a suggestion may contain code snippets longer than around 150 characters that match the training set. So the training set is the original data that they used to build the model. Means in about 1% of the cases, you get an exact copy of the original training code. And that, of course, from a copyright law perspective, is an interesting case. Yeah? And also what I found interesting, and I looked that up to verify this, in the beginning, when Copilot was in beta last year, the claimed number was 0.1%. Now it's around 1%. Yeah? And OpenAI, as the creator of the basis of the foundation of this whole tool, they clearly state that the output can contain parts that are subject to third-party licenses, including open source. So it's really in their terms. So it's no surprise. Everyone is aware about that. So what does that mean? Also here I made this, I split it up in 2 parts. The first thing is, as we learned, as we have heard, it might be an exact copy of original code from the training data. In these cases, you can, in my opinion, simply not say, but it's from Copilot or some other tool, and therefore the original license doesn't apply any longer. Yeah? So if it's a direct copy, you cannot use such a tool as, I call it a code washing machine or license washing machine, to then say, now the original license does not apply. Okay? So that's important. Another precondition for that, of course, is the code needs to be copyrightable. So it needs to be above the threshold of originality, for example. So this threshold, by the way, is relatively low. So the bar is low. Can be 1 line of code if it's smart enough. But basically, it's always, and that makes copyright law a little bit different. If you go into these depths, it's a case-by-case decision. So there is no clear-cut answer to when that's the case. Yeah. Makes it a little bit frustrating for me as a lawyer to explain that, because you would like to have clear rules and say, well, when does it apply? I sometimes have to say, we have to look at every case. So what does that mean? Verbatim copies. The original license fully applies, in my opinion. Yeah? So with all the strings attached, like attribution requirements that you have to fulfill, and all the other topics that might be in there in an open source license or any other third-party license. But for other third-party license, it might be hard to detect which one is applicable if such a license is in the training set. Yeah, I don't know. Good. Then, for the other part, cases where the code is really generated and not a copy. What does apply? And I have that in the headline, are the original licenses, are they still applicable? So imagine you are the maintainer of a cool open source project. You have skillfully chosen the MIT license for the project. And you have contributed tons of code used to train the model for Codex or any other of these models. And now you are interested, does my MIT license that I subjected the code under, does it still apply to generated code based on my original code? The answer for the EU, in my opinion, is nope, does not apply anymore. Prerequisite here also, it needs to be lawful. So this whole process needs to happen lawful. What does lawful mean? So you cannot steal the code somewhere and then train on that. That's not possible, but in the GitHub context, that was lawful. We talked about the text and data mining, and we have the T's and C's and so on. So lawful it is. You also do not have to cite anything. So there is no requirement. Yeah. That's it. In the US, it's also, again, fair use. So fair use is really the key topic in the lawsuits that we currently have, in my opinion. On the previous slide, I had this opinion where I said that GitHub does have a strong argument that it is fair use. I have that cross-checked with my US IP colleagues. They also say, yeah, looks like it, but we simply do not know. I think just last week there was a US Supreme Court decision where some people say that might be an indicator that it could be different here also. But we simply have to wait and see. And then, beside these dispute in the US lawsuit, you also have this argument of derivative works. So everyone in the open source space, GPL licenses and so on, knows the topic of derivative works. You all have heard it. That's also an interesting one, I think. So if that would be the case, so if someone successfully claims the generated output is a derivative work, then it would change the whole equation. Yeah. So, but also we have to wait and see. Yeah. Going back one step, I forgot to mention that for the input side. What can you do if you are a maintainer and do not want to have your code used? Opt out. That's what I said. The only real legal approach, in my opinion, is if someone ignores your opt-out. So if someone ignores your opt-out and you find out that your code was used for the training, you have a copyright law claim against that person or company. Yeah, that's possible. There's a question, I think, and we can quickly interrupt.
So as you mentioned, most of the laws are based on the fair use principle. So based on the legal precedents that we have in the US, because fair use is a very wide term. So do we know that what exactly we mean by fair use policy?
Yeah, so, okay, good question. Good question. Complex question. As I said, fair use considers 4 different factors. One is this transformativeness, for example, market impact and so on. I think we shouldn't look at the details here, but one thing that you need to know is fair use is a defense. It's a copyright law defense. And for fair use to work and to kick in, you first need copyright infringement. So it's a defense against a copyright infringement claim. Yeah? So that's the basic encounter. And in the US, you have case law. So you have a lot of case law topics that you need to consider. And for these AI models, the case that is cited most of the time is a Supreme Court decision regarding Google Books and the text excerpts that Google Books used from old books that are no longer in print, for example, but uses them to show some parts of these books in their Google Books offering. Yeah? And people say this case law example can be transferred to this current case of model building. If that's the case, honestly, I'm not the right person to answer that, and we have to wait and see. Yeah.
Given that both GitHub and GitLab actually host your code in the US, is it still enforceable that EU laws apply to the scraping of that because it's being scraped in the US, not being scraped in the EU?
Yeah, you're completely right. So it really depends where you perform the actions under copyright law. I just wanted to give you an overview how the situation is in different jurisdictions. Probably the scraping happens in the US, so that's where it's really decided. But as I said, this is not just about GitHub or some. It should be more general. It should give you a more generic overview of the topic and the legal questions. Yeah. By the way, the EU is not the only jurisdiction where such regulation exists. Japan and Singapore, they have similar laws enacted by now. Good. If there are no other questions, we go to the next output slide. And that one is also interesting, and I get a lot of questions about that topic. And that also creates a lot of follow-up questions, in my opinion, where we might not be fully able to answer everything just now. So code is generated by GitHub Copilot or similar tools. And what I can tell you is, in most jurisdictions, the generated code will not be protected by copyright law as it stands today. So it will be, depending on the jurisdiction, public domain, for example. You could say that. In Germany, it would be gemeinfrei, even if that's not 100% equivalent to public domain, but yeah, somewhat similar. But it simply doesn't enjoy copyright protection. And you have to know that. There are exceptions to that rule. I mentioned them here: UK, India, Ireland, Hong Kong, South Africa, and New Zealand. They have provisions in their copyright law for machine-generated code. But these do not exist in the rest of the world. And why is that? Because of one of the basic foundations and principles in copyright law. Everything is about the works that you create in copyright law that are protected. In the US, it would be a work of authorship. That's how it's called. In Germany, for the German speakers, it's a persönliche geistige Schöpfung, so personal creation, your mind that is necessary. It basically needs a human being to create something. Yeah? Otherwise, it's out of scope of copyright law protection. That's how it is. And that creates interesting follow-up questions and topics, in my opinion. One thing is what I was asked: what happens to code that I generated and then extend and then improve and so on? So if you extend it and add something to that that works separately and is above the threshold of originality, it would again enjoy copyright protection if you do it. Yeah, it's different if you just extend or refine your prompt. That wouldn't help. Yeah. Another topic is, which I think is interesting, the prompts that you ask the tools or that you create to solve your problems. They themselves can enjoy copyright protection if they are clever enough. Yeah? So you can put them under copyright protection. So that's how it is. Yeah. What does that mean? We have the first cases in the US, not from the software space, but other creative space, where someone created a graphic novel, for example. And all the pictures there were machine generated, Midjourney or similar. And this person really put a lot of effort to create all these pictures. And the pictures were created with text that the person wrote. And then the person applied for copyright registration, which is possible in the US, not in Germany, but you can register your copyright. It gives you some advantages in the US. And the Copyright Office there, that's the latest decision, said the pictures, they are not protected by copyright law. Because of what I said before, because they are machine generated. It doesn't really matter how much effort you put into that. It's the machine that generated it, and you did not have the influence that is necessary for this creative process of a human being to create something. So that just isn't enough. The text that you wrote for this graphic novel, they are protected by copyright. Okay? So it's some kind of mosaic. Copyright law knows that principle also. It could be a compilation in the US. This whole work together could be a compilation. It will be protected as a compilation. But the individual pictures, they would not be protected by copyright. So you could take them and use them for other purposes without asking for permission. Okay? Another topic that I would like to mention is if you use such a tool in your daily work and, for example, work in an area where you provide coding services and you have contracts in place that say at the end you give me the work product that you created for me and I get all the exclusive rights to the work product. You might be in trouble if you haven't talked about that, because you cannot really give exclusive rights to something that is not copyright protected. So non-exclusive rights, that would work, yeah, but you should clarify that. So that's because otherwise the delivery could be defective, yeah? At least to German standards. Just speaking for German standards here. Another topic where I thought about and I think might be interesting for you is CLAs. So some of you might have signed a CLA. Perhaps go back and read that CLA again and try to apply that logic here. If you use Copilot, if the CLA talks about works that you contribute back, you perhaps also talk to the maintainer or the one behind that project of the CLI to disclose that you use Copilot or a similar tool. Because, as I said, you cannot give at least exclusive rights. Exclusive rights should work, but I think being transparent here would be a good practice. Okay. Then, favorite topic, lawsuits. There is no new technology without lawsuits. And in the legal department, we also say the law follows technology. And I think that here is the perfect example. Excuse me, I just have to drink a little bit. Many of these questions are simply open. So the laws were not prepared for that new technology. And now we have to see what courts make out of it. And of course, Copilot was challenged already. There are federal class action lawsuits of open source developers who especially challenge this fair use argument. So that will be the key point of this dispute. And what they claim is that the original license apply and that there is copyright infringement because the generated code doesn't carry over the license text, for example, or the copyright statements that they've put in the code. And various other topics like, I think initially it was also unfair competition, for example. That was one of the topics that was dismissed early on. So in US lawsuits, it's a bit different than in Germany. Parts can be dismissed early on. That was one part that was dismissed, this competition topic. But the most important thing, the breach of license claim here on the right, that's moving forward. And the lawsuits themselves, they're also moving forward. And the court gave the plaintiffs the chance to amend some of their topics that would be dismissed otherwise. So they are still in the game. And of course, the whole legal world working in that space is monitoring that lawsuit. And I'm really curious. I cannot really make a prognosis what will be the outcome. We simply have to wait and see. Question?
Felix, thanks. But do they have real evidence for this? I mean, if I want to sue someone because of potential copyright infringement, I would assume that I need to have some real evidence where code from my open source project has been taken or has been reused as a result of Copilot.
Mm-hmm. So I see you work for the opposing party. And your legal mind came up with a very good point, I think, and that's what they claimed in their motion to dismiss, for example. They said you didn't prove your standing in that case. How are you even affected? Can you prove that? That was one of the arguments. I think it's a very valid argument, by the way. Still, the court said for now it's plausible enough that they were affected. So it's moving forward. But good thinking. Other questions?
Yeah, it's basically about the slide from the beginning, because you showed this statement from OpenAI that the generated code may be actually copyrighted, and it's up to the user to check it. Then my question is, because I assume I don't use Copilot, so I don't know, maybe this question is invalid, but if there is no indication of copyright license for this part of code, you are not sure as a user if this is this 1%, which may be copied from another code directly, or maybe not. Then instead of spending a few hours to write this code, you should spend a few hours to ensure that this is not copyrighted.
Yeah, so it's also a valid point in my opinion. I think much of the confusion regarding that topic is that Copied or Not also came up with the early beta that they did. You can go to Twitter and search for these entries at the time where people generated code that originally came from the Quake game engine, for example. And at that time, it also reproduced the comments in the code, where you could see the original license, for example, and topics like that. So that also, brought people to the point where they said, okay, we need to check that. Does it copy code, or does it really generate code, or how does it really work? They offer options by now to filter this kind of what they call public code. So they try to find a technical solution to the problem. I don't know yet if that really works, so needs to be evaluated. And otherwise, they if they go to the FAQ of Copilot, they recommend to do what they call an IP scan. IP scan is, there are scanning tools available with their own knowledge base, with almost the whole open source space, where you could detect these snippets. Yeah. But of course, it's effort. So it's effort and costs time and needs to be part of your evaluation of the tool. Good. One more.
Sorry, it's maybe a little bit of a silly question, but I just thought if I want to get a PhD and I ask something like ChatGPT to write my doctor's thesis and the prompt is actually copyrighted, can I then, is this maybe the new Gutenberg shortcut something for me? I know it's not code, but...
I wouldn't do it, honestly. I wouldn't recommend it. Because the output still, so if you played around with it, I think you can still quite good identify or have some markers. And what I read is that they also try to invisibly mark generated text. Yeah? So that's, I think, on the agenda. Perhaps you can work around that, of course, remove the watermark or similar again, but I wouldn't do it. So what I said before, law follows the technology. Here, what we also have, and I wanted to mention that because it has an open source reference in it, there is EU regulation coming up regarding AI topics. There's a draft, that's the version from a few weeks ago. And that is interesting in my opinion, because this here explicitly does not exempt open source models from this regulation for a specific case. So it says the regulation shall not apply to AI components provided under free and open source license except to the extent they are placed on the market or put into service by a provider as part of a high-risk AI system or in systems falls under Title 2 and 4. Title 2 is prohibited AI systems. Title 4 are special systems that need additional transparency. So if it's open source and not within these three areas, it's not regulated. And in the next sentence it says, this exemption shall not apply to foundation models as defined in Article 3. So the EU says foundation models, which can be multi-purpose and reused many times, they are so important and perhaps also dangerous to some degree that they need to be regulated, even if it's open source and coming from the open source space. What does that mean? It puts a lot of work on the providers of these systems. Providers also could be an open source project. Then Article 28b, you must make sure that you comply with all the requirements before you put it on the market. They are defined in that article, we don't have to discuss them now, but it's really effort. It's really costly, time-wise, money-wise, and you need to be aware because the regulation will obviously also will have sanctions, perhaps, if you fail to comply with it. So applies to open source and to open source licenses. And with that slide, I'm through with the presentation. Are there any more questions?
So, how does code generation copyright applies when you're the one that created the tool for code generation?
Not sure if I get the question.
Let's say that I create a tool that generates code. I created that tool manually. I created it myself. Copyright applies to it. And then I ran it to generate more code. Who owns the copyright to that generated code?
Nobody. So if you write Copilot, you own the code to Copilot. you own the copyright. If you use Copilot to generate new code, it's not protected by copyright law. If exception, it outputs your original training data set that you used and where you have the copyright. Then it might be different for that portion. But the principle is, like I said before. And by the way, so regarding the models, that's also something I find interesting. The model, so like Codex, is also not protected by copyright law because the same principle applies. It's not really generated by a human being. So it's a technical process. There, most of the time, and most people say it's trade secret laws that apply, for example. Others argue about patent law. Can argue about that. Potentially, possible, yeah. Definitely, AI space there's a lot of patent activity in the AI space. But trade secret is a safe bet, but not copyright law for the models also.
Follow up to this question. What if the tool is not generative in nature, but just transformative? So let's say that you have a Copilot that does not completely generate the code, but only transforms it. Does that change the copyright of any existing source? Or does it completely invalidate it or keep it the same way?
So we would have to define more closely what transforms in that case or your example means, because I can tell you if transforms in, let's say, a way of translate, and previous times you had tools that could try to translate from one programming language to another, for example. Yeah, that translation part, that would be subject to copyright law. So these actions would be subject to copyright law. Also the output. So you would need the right to do that, to do the translation, and the translation would also be considered protected. But it really depends what you define under transforming.
So we have a question from the chat here. Maybe we've touched on this before, but Anil asks, when a user or a legal system looks at a source code, how would they recognize if it was implemented using Copilot or not?
Right now you don't. So there's no marking or something like that. It's just not there.
Maybe a follow-up of that. You mentioned before that OpenAI says that maybe 1% of the code could be verbatim copy. So do you know when that happens? Because maybe you get the code that is exact copy and now you are basically just getting the same open source.
Yeah, it's a good question. As I said before, they are trying to fix this topic with an option to filter. Yeah, so perhaps it isn't even a topic anymore because that came as a feature later on. And I honestly didn't try that myself. Yeah, so I would have to. So if it can be solved technological by enabling this filter option, yeah, you don't have the issue. They also work, as far as I know, on showing alternatives and showing where it does come from, the proposal, yeah, and the original license. But as far as I'm informed, it's not there yet. But they identified it as a potential issue that people are interested in. Otherwise, right now, you just do not see it. You would have to do the scan, this what they call IP scan. There's a specialized scanning tool to double check, at least against the open source training code.
One short question.
You mentioned the word derivative work. And I remember there were lawsuits around Linux where SEO said, well, you have seen source code of Unix, so Linux is copyrighted by Unix because you had the chance to see the code, so you were influenced as developer, and we claim the copyright on that. What's the status currently of these things? Because you could say, okay, the AI is influenced by my code, so it's my copyright.
Yeah, so this derivative works topic, I honestly would need probably 30 more minutes or So, but I can tell about the SEO. So this is a zombie lawsuit, and it became active. I read some weeks ago again. Somehow, I don't know how it works, but somehow it's active again. So with the derivative works, just seeing someone else's code and then creating something new, that's not in itself a derivative work. So it's not that simple. As I said, ideas are not protected, and of course you can learn from others. You can go to your local library, you can read every biology book, and then write your own biology book. Of course you are influenced by the knowledge that you read. It's not necessarily a derivative work. Yeah. So there are more components to that discussion. It's not that simple.
It's not that simple. What an ending. Thank you very much, Felix, for joining us.